remarked, I got my first law degree across the way at Osgoode Hall Law School. I lived on this campus for 3 years. I remarked to Susan that the view from my room last night was the identical view that I had for 3 years as a law student. And then I spent 14 years here as a faculty member, including helping to set up the center that Susan now directs. And so it is in every sense a real delight to be home. And James, Susan, and all CRS colleagues, thank you so much for inviting me back. And you've even found me a clicker. This one?
Yeah. Yes, that way.
Okay, I can do that. Thank you very much. I was actually very pleased to hear the President's words this morning that it was important, even as we celebrate the 60th anniversary of the Refugee Convention, not to lose sight of the fact that there are, in fact, enormous challenges in refugee law. And I think one of the worries I have is that in our celebratory mode, which seems to be the order of the day in myriad locales around the world over the next couple of months, we may in fact do a disservice to the Refugee Convention by honoring it in a superficial sense rather than engaging with it in a substantive sense. You'll see the title for the talk that I've put on the screen, Saving International Refugee Law. And I do this intentionally because it is my fear at this stage that the singular importance of international refugee law really is profoundly misunderstood by virtually everybody. Now, of course, nobody in this room, but all of those out there. And hence, I thought it would be an opportune moment for us to think hard about what I see as competing erroneous claims by governments and by advocates in particular about its structure and its purpose, which seem to me to threaten the continued ability of refugee law to play the truly unique human rights role that only it has at a time when there is absolutely no meaningful alternative in sight. If we are truly going to celebrate the treaty, we need to do it by engaging with the need, it seems to me, to renovate its mechanisms. Not to rewrite the treaty, but to renovate the way that the treaty works. Now, what do I mean by competing erroneous claims? He says, hoping the button will take us there, and it takes us there too quickly. Let me begin with governments of the developed world, which it seems to me are today appropriating the language of global burden and responsibility sharing in refugee law to further an only mildly attenuated global apartheid regime, and I use that term quite intentionally. A regime under which most refugees not only remain in the less developed world, but remain there under conditions which are frequently rights abusive and often literally life-threatening. What is it that these wealthier states are saying? They have, in my view, distorted the object and purpose of the Refugee Convention, suggesting in particular that it imposes on them only a duty of last resort. That is, that refugees may routinely be sent away to any other state that will admit them without risk of return to their country of origin. That is false. Secondly, they have stigmatized refugees who arrive without pre-authorization at their territory as illegal, despite the fact that the Refugee Convention itself requires otherwise. And perhaps most disingenuously of all, they have sought to justify their harsh and often illegal treatment of refugees arriving at their territory on the grounds that that harshness is the necessary means to rationalize the allocation of resources toward a more appropriate protection end, namely sending the resources to the regions in which most refugees are found, rather than spending them here. And I want to deal with each of these three claims. But at the outset, let me make it clear that I believe each of these claims to be a distortion. First and most fundamentally, despite the Dublin regulation, which every time I teach in Europe, particularly when I teach students who are perhaps 20 or 30 years old, they look at me with just this incredulous expression when I say, do you know what? There is no such thing as a country of first arrival. It does not exist as a matter of international refugee law. And that is true. It does not. There is no duty whatever on a refugee to seek protection either in the first country she arrives at or more generally within her own region of origin. There is nothing in the Refugee Convention, there is nothing in the so-called soft law standards agreed by state members of the Executive Committee that so requires. To the contrary, unless a refugee has actually found protection elsewhere, and those are important words, found protection, meaning actually acquired it, not just could ask for it, and found protection, meaning the whole bundle of protections guaranteed by the treaty, not just protection against refoulement, then the standards of international refugee law today actually require deference to the wishes of the refugee himself or herself as to where to take her chances. Now, let me emphasize that last point as well. My point is not that the refugee gets to decide where she will be admitted as a refugee. She does, however, have the right to decide where to make her claim. Even as the drafters of the 1951 Convention moved away from a 40-year history in which the international agency, UNHCR's predecessor, actually made refugee status assessments and gave that power to individual governments, the quid pro quo was that even as each state could administer its own system as it chose, the refugee herself could decide which system to apply to. Second, refugees who arrive at a state's territory, indeed any refugee who comes under a state's jurisdiction, including, both Europe and Australia are listening, including any refugee who comes under a state party's jurisdiction, and that includes parts of the high seas over which a state has taken effective jurisdiction. Any such refugee is entitled to the provisional benefit of the Refugee Convention. Efforts to resist responsibility grounded in the alleged illegality of arrival or presence are fundamentally at odds with the Convention's requirement that refugees in flight from persecution are to be granted immunity from any penalties for illegal presence or arrival. The drafters knew, I mean, this convention is brilliant. I am an evangelist for this convention. They spent 3.5 years drafting this document, and they did a job that in my view has withstood the test of time. They knew, even in 1948 when this initiative began, that no government would grant refugees a visa for the purpose of coming to make an asylum claim. Professor Heilbronner in Germany has suggested they should. I agree with him. No one has done it. They talk about it, no one has done it. They may resettle the ones that they like and they think will be good citizens, but they do not grant visas for the purpose of making a refugee claim. To insulate the need for protection against the pervasiveness of visa requirements, the drafters inserted Article 31 that insists that refugees may not be stigmatized or penalized for breaching ordinary migration control laws in the context of their search for protection. It is thus completely inappropriate to stigmatize refugees arriving without visas as lawbreakers. To the contrary, a treaty we have signed provides exactly the opposite. Third, it is increasingly said, and this is the complex claim, it is increasingly said, in particular, I must say, by the government of Australia, that the harshness meted out to the minority of refugees who arrive at the frontiers of developed countries can be justified as part of an overarching strategy to reallocate protective resources from wealthier asylum states to the regions of the world where most refugees actually live. The strategy is justified not only on the grounds of the relative numbers of the refugees here and there, I'll come to that point in a moment, but more fundamentally on the basis that refugees in the less developed world are, to quote from the Australian government, most in need. The reallocation of fiscal resources towards the less developed world is sometimes accompanied by a commitment to resettle some number of, quote, those most in need. That is, it is said that a greater commitment to resettlement has been made possible by the savings realized by shutting down what the government views as illegal, that is, unauthorized refugee arrivals. Now, this third point is more complex than the first two, and it takes a little longer to untangle. There is absolutely no doubt that there is a maldistribution of refugee burdens and responsibilities in the world today. Between 80 and 90% of refugees remain in the less developed world. A sight that I'm astounded seems so infrequently to cross the radar screen of government officials in the developed world who cry when a few hundred refugees arrive off the west coast of Canada, or perhaps 1,000 show up on Lampedusa. I can recall a time in Tanzania when 150,000 refugees an hour were arriving. I just want to make sure we put this in perspective. Our burdens are infinitesimally small. If one looks at it in terms of the number of refugees per citizen, we've got states like Chad, Iran, Jordan, Lebanon, Pakistan, Saudi Arabia, Syria, where there is at least one refugee for every 100 citizens. In contrast, in Canada, the number is about 1 to 460. In the European Union, in the United States, 1 to 1,900. Japan, 1 to 41,000. Not only is the less developed world doing the overwhelming share of refugee hosting, but it does so with a small fraction of the resources presently allocated to processing and assisting the tiny minority of refugees who show up in richer states. In rough terms, we spend about 50 cents a day to look after each of the millions of refugees under UNHCR care in the less developed world. And not even that tiny budget is guaranteed. UNHCR is guaranteed about 2% of its annual budget and may, with all due respect, be said to be forced to go begging every year for the balance of its budget from a small number of richer countries. That's what we do for refugees in the less developed world. In contrast, a conservative estimate, now 5 years old, was that we spent at least $20,000 per refugee simply to process their claims. Forget the social support structure in the developed world. That means we're spending roughly 100 times more on every refugee in the developed world compared to a refugee in the less developed world. An equation that, to my mind, is not even on the equitable Richter scale. So this third claim is an important one. When governments say, we're acting as we are because we're going to send the money there to do the job that needs to be done there, the starting point seems rational. Indeed, examined from the optic of hosting capacity, the question is even worse. If you look at the number of refugees per $1 of domestic GDP, for each dollar of domestic GDP, Pakistan, for example, hosts 745 refugees. Germany has the highest ratio in the developed world. They're, in contrast, 17 refugees for every dollar of GDP. Again, not even close to the equitable Richter scale. And so it should, and with all apologies to those of you from the less developed world, I think we have to be equally candid. It should come as no surprise, with this sort of a complete maldistribution of resources, that the conditions under which most refugees live in the less developed world are, may I be candid, appalling. There are some states, including South Africa represented here, that have really struggled valiantly to provide genuine rights to work and otherwise to refugees despite the large numbers they host. That is the aberration. Most refugees in the less developed world are held in long-term detention and or denied the right to work and or denied the right to education, what the U.S. Committee for Refugees has rightly called warehousing. Those actions are simply illegal, and I'll come back to that point. But one can understand, with the maldistribution of resources, why such governmental responses persist, and at the very least, why the rationalization that they provide may seem to be salient. If we're going to talk about reallocation, though, we have to not just talk the talk, but walk the walk. And that's where even Australia, which has led this charge, has fallen down flat. There has not been a massive reallocation of resources away from the developed world and towards the less developed world, despite the promises to do so. What there have been are short-term, discretionary, non-binding, occasional allocations of resources, usually through UNHCR, which the developed world can then control through the power of the executive committee. It's no surprise to me, therefore, that statements like that on the screen from the representative of India at the executive committee persist. Why should we sign on to a treaty that imposes obligations on us when we are on the front lines of protection and those of you insulated by geography and blessed by wealth do so little? And I think that is a challenge that we must absolutely meet if this convention is to survive. Again, what is going on now in most of the less developed world is simply patently illegal. If what we are doing under the guise of burden sharing is funding UNHCR refugee camps that effectively keep people behind barbed wire and unable to get on with their lives, we are complicit in a breach of the Refugee Treaty under the guise of burden sharing. That is the reality. About a third of the world's refugees live in camps, that number rising to more than 60% in sub-Saharan Africa. More than 5.5 million refugees are today in what the UNHCR calls a protracted refugee situation, meaning that at least 25,000 refugees have been waiting for more than 5 years for a solution with none in sight. If that's what we're funding, we are not funding a solution. In this context, if we are actually going to talk about transfer of resources, we need to be transferring resources to do what the Refugee Convention requires, not throwing money at the less developed world as a sop to our consciences for the harsh treatment of refugees in our midst. If we know that what we are in fact doing is funding policies that fail to do precisely what the Refugee Convention requires, namely promoting safety, autonomy, and self-reliance, not perpetual encampment behind barbed wire, then we are doing a wrong rather than doing a good. Now the developed world says, oh yes, but we're in there with resettlement too, and we will put some of our resources towards bringing out from the overburdened, less developed world those refugees who are, quote, most in need, unquote. We've got to be frank about this, though. The numbers of resettlement cases are completely insignificant in statistical terms. About 128,000 places on offer in 2009 from only a fraction of the world's developed governments, not even coming close to meeting the need for residual resettlement of people who, for example, can't safely go home after even 5 years in the purgatory of a refugee camp awaiting a solution. Indeed, the number of states making major resettlement offers has declined from 23 just 5 years ago to only 19 today. With only a few exceptions, moreover, and I really want to emphasize this because governments, including my own government of Canada, get away with a little too much on this. With the exception only of programs like the Women at Risk and Unaccompanied Minor programs, we do not resettle people out of the camps because they are the most in need. We, Australia, the United States, and others resettle those that we believe are going to be the best immigrants here, as among those who are refugees. Now, there's nothing wrong with that per se if it's an immigration program. But to suggest that we do that in lieu of admitting at our shores those who have a clear need for protection on the basis of that need alone is simply disingenuous. UNHCR has complained about this in its ever so quiet way. You see it on the screen. You know, at the end of the day, countries of resettlement make the decisions. All we can do is ask. And indeed, that's true. It's not UNHCR's fault. The fault is ours. And finally, It must be said, to look at this argument, that as important as it is to protect refugees closer to their homes, I don't like the trade-off that's being posited in the governmental rhetoric. There is simply no reason to stigmatize those who flee farther afield as, quote, less deserving, unquote, than those who remain in their own region. As many courts have insisted, including both the Federal Court of Australia and the Federal Court of Canada, I'm proud to say, there are often very good reasons why refugees do not seek protection in their own part of the world. Safety and security ranking very high on the list, but the absence of fair status determination systems or any meaningful ability to reestablish themselves socially and economically being valid concerns as well. Because we know that there is in fact no protection worthy of the name, much less in line with legal obligations, being provided in the majority of the less developed world today, it is dishonest to stigmatize as less needy those refugees who either have the resources to get here or who, quite frankly, mortgage their future to traffickers in order to seek protection in a place where they believe they will be treated fairly. I was distressed enormously when I was back in my home in Vancouver last summer to watch the rhetoric. It was disgusting, if I may be candid. Yes, people who were refugees had paid traffickers to get here. But may I ask a question? Which one of you sitting around this table, confronted with the risk of being persecuted because of who you are or what you believe, and having no local meaningful alternative, which one of us would not either spend every last dollar we had to hire a smuggler to get us here, or if we didn't have the money, mortgage our future, even to a life-threatening trafficker in the hopes of surviving? That is a completely rational choice, which the system we have built compels. It is completely inappropriate to stigmatize it as anything else. In sum, then, the official rhetoric in the developed world is, in my view, largely unhelpful. First of all, refugees are not required to seek protection either in the first country they come to or in their own region. Second, they are not acting unlawfully by arriving to seek protection in a state party that has not pre-authorized their presence. And as valuable as it is to promote the sharing of burdens and responsibilities on a more equitable basis, that goal is not being served by a system of purely discretionary resettlement or of fiscal transfers that promote or sustain a local response that amounts to itself an abuse of refugee rights. And that's where we're at today. Now, lest it be thought that my tirade is directed exclusively at government, let me now come to the advocacy community. Because quite frankly, what we have is what the French call a dialogue de sourds, a dialogue of the deaf, where governments persist in making claims that they know, or at least their legal advisors know, are false. Similarly, advocates, in my view, make claims that they ought not to be making, which similarly stymie the ability to find a solution to the problem of keeping the Refugee Convention alive. First, refugee law does not require states to admit refugees as permanent immigrants. I'm sorry. Refugee law is not immigration law. It is human rights law. It requires protection that meets international standards for the duration of the risk. What has sometimes been called temporary protection, sort of a silly name because we never know how long it's going to be, what I call protection for the duration of risk, is a completely valid construct and is indeed precisely what the Refugee Convention requires. No more, but no less. Refugee law simply requires the right of seriously at-risk people to cross international borders and to be accommodated with guarantees of safety and dignity until and unless the threat in their home state is eradicated. Advocates, when they assert the duty permanently to assimilate refugees on a routine basis, raise the stakes for government. They up the ante. they turn what should be a protection debate into what governments rightly see as a discretionary immigration debate. That is not helpful. The decision about whether a refugee may stay permanently or not is a discretionary decision. Article 34 of the treaty simply requires governments to give good faith consideration to the option. It does not require it. When we say as advocates to each government that you may not simply grant refugee rights to those who meet the definition and ultimately require those who can safely return to their state of origin when the harm is eradicated, we change the color of the debate and we turn it into one that governments see as invoking their discretion over permanent in-migration, and that is not a good thing. The response of governments, as we again saw recently in this country and in Australia and presently in Europe, is if this is in fact an immigration decision, we intend to assert our sovereign control, which is precisely the opposite of what the treaty we've signed on refugee law requires. It requires a needs-based exception, but it does not require permanent immigration. Secondly, many advocates have, I think, unhelpfully poo-pooed the idea of burden and responsibility sharing among states. It is not the case that the state at which a refugee physically first arrives has the sole responsibility to look after that person's needs. To the contrary, at least up to the point where the refugee is what the treaty refers to as lawfully present, meaning in the context of a system like Canada's, once it has been admitted for assessment of status. Up until that point, it is perfectly lawful for a government mandatorily and without the refugee's consent to share out the responsibility to protect with another state party insofar as there has been what the UK Court of Appeal helpfully refers to as extreme vigilance of the record of the destination state, not just on refoulement, but on respect for all refugee rights. If pre-lawful presence, another state party can and will live up to all responsibilities under the Refugee Treaty, refugee responsibility sharing is lawful under the Convention. Now, I realize that at this point I've probably alienated virtually everybody, and that is in part my goal. The only people who lose out in this debate, polarized on one side in the way that you see on the screen and the other way by the governmental rhetoric I described previously, the only people who lose out on this are the refugees. They're the group I care about. They're the group I believe everyone in this room cares most fundamentally about. And the NGOs and advocates are going to have to attenuate their rhetoric, just as the governments are going to have to quit stigmatizing directly arriving refugees as illegal, or otherwise insisting that they haven't got protection responsibilities to them. Those two forms of rhetoric are not helpful. What I want to suggest is that we get away from this silly, unhelpful distortion of the Convention and try to make the Refugee Convention live. Now let me pause and suggest why I think this convention is worth saving. There are some who think otherwise. There are some who believe we should just start from scratch. I think that would be a disastrous move. I want to underscore that. UNHCR has occasionally stigmatized me as calling for the renegotiation of the treaty. I have never once said that. I will never say that. But I do believe that the mechanisms of the treaty need to be renovated. And that's what we ought to be, I believe, recommitting ourselves to. Why should we save it? The beauty of refugee law is exactly what many advocates don't like. The beauty of refugee law is that it is reconcilable to states' migration control programs. That's why it's lived 60 years. The treaty was drafted to achieve a delicate balance between the non-compromisability of a refugee's right to seek protection and the ability of states to manage that flow in ways that were reconcilable to their own interests. So, for example, only a subset of human rights victims can meet the well-founded fear of being persecuted for a convention reason test. the need to link the harm at a very high level to the norm of non-discrimination. Some say imposes too high a test. I say to the contrary. It imposes a very high test that justifies the non-discretionary nature of admission. The nature of what's owed, the fact that refugee rights are only owed under what I call levels of attachment. Not all refugee rights are immediately owed. More and more rights are owed over time, reconciling refugee rights to the realities of the receiving state. The contingent rights structure, that refugees never get more rights than the people of the host country get, again, reconciles refugee law to the realities of host states. The ability to share out the responsibility for protection, again, recognizing that some states will at times be overwhelmed and need to share. All built into this treaty are enormous points of strength in my view. They are what has kept this alive. The bottom line is, whatever governments do, and history proves this so well, whatever governments do to try to keep refugees out will fail. It has always failed. Truly, truly desperate people, at least some minority thereof, are always going to get out, and no matter how sophisticated the systems the developed world puts in place, will find a way to get in. Unless you actually believe that in a world that is interconnected as ours, we can stop, point blank, the transport of all such persons and still keep airlines flying, boats on the seas, borders admitting workers across land borders each day. Unless you actually believe that's possible, and no government has ever achieved it, then governments need refugee law. It sustains the protectionist norm. It says to governments, you may in most cases exclude such non-citizens as you wish. The only exception is this narrow one. That narrow exception legitimates the protectionist norm and allows governments at an ethical and political level to sustain their overarching program of migration control. That is a good thing for states, and states know it, even if they don't articulate it. I think it's time to hold governments accountable to this. This is a system that not only provides remedies for people, it provides a basis upon which governments may lawfully, and in line with their own values, keep migration control for most would-be entrants afloat. That point about basic values is not unimportant. Europe in particular has seen both the European Court of Human Rights and now the European Court of Justice quite appropriately insisting that the ways in which refugee protection and migration are to be managed has to be consonant with basic values. That's the legal structure that we've agreed to. If we're going to be compelled to go there, then we ought to take advantage of a regime that quite frankly works quite well. It rejects arbitrariness in the admission of at-risk persons, linking it to the most egregious forms of harm, persons who are at risk by reason of who they are or what they believe. It establishes a principled means by which to keep migration control afloat. It will, if you will permit me a very tired metaphor, refugee law is the sluice gate in the dam of immigration control. Just like a dam on a river. But for the sluice gate, there would be unstoppable inundation, there would be the inability to control. Refugee law provides those advantages to government, and those of us in academic life and in public policy more generally have a duty to make clear to states why this regime actually, at the end of the day, assists border control. So how do we revitalize it then? Just a few thoughts before we open this for discussion. How do we actually take a treaty that I think is worth saving and make it work in a way that states continue to see it as reconcilable to their self-interests, in particular to their migration control objectives, yet which does not compromise the right of refugees to access true protection? That, I think, has to be the challenge. How do we maintain faithless states that pursue this regime for reasons that have largely to do with migration control, even as the right of refugees to access true protection, not encampment, not simply non-return, true protection in line with the treaty, Articles 2 to 34, how do we achieve that compromise? First, I think we say, firmly and without embarrassment, that there is no legal prohibition of limiting refugee status and the rights attached to it to the duration of risk in the country of origin, of seeing refugee protection as a human rights remedy, not as an immigration path. Now look, there are the obvious caveats. Some cases will call for immediate integration. Unaccompanied minor refugees, severely traumatized persons being the clearest and most obvious examples. In a project that I actually led on this campus just over a decade ago, the social science expert teams that examined this question of protection for duration of risk agreed that the case for finding severe psychosocial harm due to the lack of a permanent solution, so long as rights were respected, was negligible until at least 5 years had passed. If we were to say that rights regarding protection for the duration of risk requires a permanent solution only at the 5-year point, we would still be regaining 50% of current asylum capacity. Roughly 50% of refugee flows are resolved within the first 5 years. That is a monstrous revitalization of capacity of the refugee treaty that could be achieved without any cost to refugee protection. Second, assuming the caveats that I've already noted, we should acknowledge that governments may in fact allocate the responsibility to protect refugees between and among themselves. But again, I want to be clear. I am not talking about the Canada-US dumping deal. I am not talking about the so-called Dublin regulation. Much less am I talking about what Australia is trying to negotiate with its Pacific nation neighbors at present. What I'm talking about is a genuine rights regarding allocation of responsibility. It slayed me, I must say, and I realize with 3 federal court judges around the table I should be careful, but it slayed me to read the extraordinarily articulate judgment of the single judge of the federal court examining the Canada-US agreement, which found multiple breaches by the United States of international refugee law obligations, and then to see the Court of Appeal on admittedly well-founded but nonetheless technical grounds refusing to engage the substance of the issue. At the end of the day, Canada is complicit under international law in the return of individuals to rights violations in a state to ourselves, and we know that. Australia has taken the view that it doesn't even need to ask that many questions. The only question is, will some other country let you in? It doesn't even care whether it's a state party to the treaty. The Dublin regulation simply says first date of arrival unless you've got concrete connections. Thank God the European Court of Human Rights and now the European Court of Justice are engaging on the issue. That willful blindness is not what I am talking about. What I am talking about is actual vigilance of the quality of protection that meets Refugee Convention and international human rights standards in a refugee party state. That can never override core protection responsibilities. Moreover, and here I speak to my colleagues from the less developed world around the table, that process of sharing out the fiscal burdens and human responsibilities of refugee protection should not be unilaterally engineered by the developed world. If we're going to have this discussion under the guise of more fairly sharing out responsibilities with the less developed world, then it is time that the developed world took the less developed world a bit more seriously and actually engaged with it at the level of principle. We are talking about moving toward a system in which there is common but differentiated responsibility. States have done this in many other fields. Indeed, they've done it in the refugee law field. They've done it through CIIRL, they've done it through the CPA. We seem incapable of learning the positive lessons of past refugee experience, much less of those in free trade, the environment, economic development, shared heritage, and elsewhere. Yes, states would come to this as a form of collective insurance, and some advocates think that's a bad thing. I say get over it. If it produces the positive result, the fact that governments are motivated by a desire to insure themselves against an unstoppable flow is not something to be concerned about. More specifically on the financial side, a globalized system of common but differentiated responsibilities should encompass not the current charity model, where the occasional sub-Saharan African state gets a bailout from UNHCR or the developed world, but a binding obligation to shift protection dollars to where most protection needs to happen. Yes, some developed countries have argued for this in principle, but none, not a single one, has offered to formalize a truly binding system of resource redistribution that would dedicate at least the same quantum of funds now going into RSD in the developed world to the poorer regions of the world where most refugees are. Binding fiscal burden sharing must replace the fickleness and the unpredictability of the current charity-based model. In terms of the actual human dimension, I think we should also recognize that different countries can contribute to the human process of refugee sharing in different ways. There's no reason to protect a cookie-cutter model where every state does all of the same things. There are very real differences in the manner in which different countries can best contribute to the successful implementation of a more collectivized model. Some governments, for example, the one thing that every government must do, because the treaty does not authorize any exception to this, every government must remain open to first arrivals. Secondly, though, once one has processed the claim, there is nothing to say that some states couldn't provide the protection for duration of risk for the majority, for example, up to 5 years. Others provide the immediate resettlement of the severe psychologically compromised applicants and others. Others, including states like Canada, provide a binding undertaking to resettle not tens or hundreds of thousands, but significantly larger numbers of refugees after the 5 years of protection for duration of risk has been proven to be incapable of generating a solution. There is, with the possible exception of South Africa, no state in the less developed world today that's prepared to provide a legally binding guarantee of high-quality permanent integration. And yet they've got 80 to 90% of the world's refugees. We need to play that role. And I do not mean the crummy little undertakings that came out of Convention Plus for 5,000 or 10,000 more resettlement places. Big whoop. We're in a world of 15 million refugees. 128,000 places ought to be a source of embarrassment to all of us who claim that as our role. The precise allocation of burdens and responsibilities should be flexible, but operate against one foundational principle, and I want clearly to be heard on this. There is no amount of money that a state can contribute to the system that will buy its way out of the human dimension. Every state that has signed the treaty must play the first reception role, and all states should play some combination of protection for duration of risk, special needs resettlement, or residual resettlement when a solution is still not in sight at the end of 4 or 5 years. No buying out. But the precise equation may be different. It is very expensive and difficult to host severely disabled refugees, and there's no reason not to take account of it. Beyond that shift to a collectivized system based on common but differentiated responsibility, the other challenge, the critical goal, is to reach agreement on a system meaningfully to oversee the common but differentiated responsibility. Otherwise, this will turn into the nightmarish refugee version of the Securities and Exchange Commission, where the big players with lots of money run the show. Now, 15 years ago, I put this challenge to UNHCR, and the then Director of International Protection said, "Oh, don't really want to go down that road. Puts us in a very difficult position if we were to actually have to play the role of the arbiter of the system of common but differentiated responsibility." And my response at the time, right across the campus, was, if you're not willing to do that, you're not worthy of being the Director of International Protection. Because that is UNHCR's job. UNHCR's job, if it is an organization worthy of its mandate, is to ensure that protection on a global basis is ethically and on a principled basis well managed for all refugees. It's not a tents and blanket agency. It seems to have forgotten that. There's lots of other good groups that can do that. You don't need UNHCR for that. We need UNHCR to manage legal protection, which is a mandate that until very recently it has shied away from. I'm happy to say there's a bit of a renaissance, and I hope that they'll take on this challenge of truly leading a global reformation of the treaty, not simply a little convention plus add-on as their own internal project to honor the 60th anniversary. Now, the project that I'm suggesting is still a convention-based regime. It's absolutely based on the 1951 convention, not one word in it needs to be changed. The difference between what I am proposing and most of what has been on the table recently is that the variants of orderliness, of structure, of systemization that came out of Convention Plus and elsewhere did not begin from, nor were they primarily directed to the provision of meaningful protection to refugees. They were about making states happy. Reform initiatives need to ensure the meaningful protection of refugees first and foremost. The more comprehensive model I'm advocating is, of course, attentive to state needs. And again, I am not embarrassed by that. International law is attentive to state needs. That's the reason it exists. It's a way of getting states sometimes to do the right things, even if their motivations may not be as pure as every advocate or academic would like. But it seems to me that if we're going to talk about state interests being factored into the system, we have to stop pandering simply to the small club of developed countries that fund the UNHCR at present, and think about the interests of all states, including those that bear the overwhelming burden of refugee protection far away from Geneva. Those states have a duty too, that if they are going to receive major support, they have a duty of ethical reciprocity to accept the supervision of what they do. No more encampment for 10 years without access to work or school. So it's a quid pro quo that everyone is going to have to sacrifice on. But in my view, and on this point I will conclude, if we fail to take up the challenge, what we are doing is allowing the world's most effective human rights system, the system that every year meets the needs of more than 15 million people, the most truly desperate involuntary migrants. If we don't take up the challenge, we are allowing that system to atrophy, and all of us who profess expertise in the system, in my view, have an ethical responsibility to swallow our pre-convictions, to swallow our traditional assumptions, and to think hard about how to save what is critical in the interests of those who desperately need the Refugee Convention's protection. Thank you very much.